Hello, guys and gals. This is the algorithm rabbit hole. Today, I'm back down the rabbit hole to discuss Title 42. It's all over the news right now, and I want to take a deep dive, taking a look back at how we got here, hopefully simplify some things for the political novice, such as myself, and envision where we're headed. So I did some research, and here's what I have for you. So Title 42 is an order that was put in place during Trump's time in the White House, which references part of the United States Public Health Code. It is a clause of the 1944 Public Health Services Law that allows the government to prevent introduction of individuals during certain public health emergencies. This is how Trump was able to leverage Title 42 during the COVID-19 crisis. The Title 42 process has allowed the U.S. to expel upward of 2 million migrants from the border, including a surge of Haitians seeking asylum last year, Venezuelans arriving in large numbers, and Mexicans who make up the largest majority of unauthorized migrants in southwestern states. Criticism from human rights activists and advocates over the handling of the Haitian influx at the border in Del Rio last year didn't stop the administration from defending the use of Title 42 in court, even though it had rarely been used over the past few decades. Under federal law, any non-citizen within the United States can make a claim for asylum. To break this down, asylum is a form of protection which allows an individual to remain in the United States instead of being removed, aka deported, to a country where he or she fears persecution or harm. Under U.S. law, those that flee their country and make it to the U.S. at a port of entry can apply for asylum. If they are granted asylum, they are essentially protected from the potential threat that they face in their country because they have the right to stay in the United States now. To clarify, according to the U.S. immigration law, a refugee is someone who has been resettled in the United States through the U.S. Resettlement Program, which is a separate process from asylum. From its earliest days, America has been a nation of immigrants, from its original inhabitants to the first Europeans led by the Spanish and French, to the English who founded the permanent settlement in the present-day Virginia. But let us not forget the hundreds of thousands of enslaved Africans who came to America against their will during the 17th and 19th centuries. That in itself is a separate video that I think I may make in the future. Another wave came during 1815 and 1865 from Northern and Western Europe. About a third of those immigrants were coming from Ireland, which had experienced massive famine in the mid-19th century. Also in the 19th century, the U.S. received some 5 million German immigrants, many of whom journeyed to what is now present-day Midwest. In the national census of 2000, more Americans claimed German ancestry than any other group. During the mid-1800s, a significant number of Asian immigrants settled in the U.S., lured by news of the California gold rush. In 1908, the term melting pot was coined as a metaphor to describe the union of many nationalities, cultures, and ethnicities. The influx of newcomers resulted in anti-immigrant sentiments among Americans, particularly Anglo-Saxon Protestants, who felt that these immigrants posed unwanted competition for jobs. For much of the 1800s, the federal government had left immigration policy to the individual states. However, by the final decade of the century, the government decided it needed to step in to handle the ever-increasing number of immigrants. One of the first significant pieces of federal legislation aimed at restricting immigration was the Chinese Exclusion Act of 1882, which banned Chinese laborers from coming to America. The Chinese were blamed for a decline in wages because they were willing to work for less. The Bracero Program, signed in 1942.
I sound American as hell, don't I? Lo siento, solo hablo un poco de español.
As I was saying, it was a series of diplomatic accords between Mexico and the U.S. that brought millions of Mexican immigrants to the U.S. to work on short-term agricultural labor contracts. From 1942 to 1964, 4.6 million contracts were signed, making it the largest U.S. contract labor program to date. The program was criticized because some workers returned home with very little money, while others stayed in the United States illegally and sought additional work. I found this program to be very curious as I was doing my research, considering where things are today with Mexican immigrants and the Immigration Act that was enacted several years prior. So the Immigration Act of 1924, also known as the Johnson-Reed Act, it limited the number of immigrants allowed to enter the United States through a national origins quota. The quota provided immigration visas to only 2% of the total number of people of each nationality in the U.S. as of,
Wait for it,
1890 National Census. The act excluded Asians entirely. At that time, the idea of an immigrant to the United States was looked upon as a parent of future-born American citizens, not as a source of cheap or competitive labor, or as someone seeking asylum for foreign oppression, nor as a migrant looking for a less strenuous life. Could it be because those immigrants were coming from Europe? Who knows? In 1917, the U.S. Congress enacted the first widely restrictive immigration law, in part made possible by the uncertainty generated over the national security during World War I. This law included several provisions that paved the way for the Johnson-Reed Act of 1924. A coalition of restrictionists had lobbied intensely for the Johnson-Reed Act. Their primary objective was to restore the ethnic makeup of the country's white population to that of the early 19th century. I must also note that until 1965, the restrictions included Eastern Europeans who happened to be Jewish, many of which lost their lives during the Holocaust. As President Coolidge signed the act, he is documented as stating, "America must remain American." The act restricted these racial and ethnic groups partly due to a quote-unquote science that was believed at the time called eugenics, which basically said that these groups were more likely to be socially inadequate and become a public burden. Eugenicist Harry Laughlin, who managed the Eugenics Records Office, was appointed around 1922 as the expert eugenics agent to the House Committee of Immigration and Naturalization. He testified in 1920 about foreign-born groups in hospitals for the insane, that the Italians, Russians, Austrians, largely Jewish, constitute a large proportion of the insane. You could call this act and rhetoric, in my opinion, racial engineering of sorts, but it is also an expression of foreign relations. In addition to severely restricting immigration, the Johnson-Reed Act redefined American foreign policy. Before that, immigration had been brokered through international treaties and negotiations. With the act in place, America alone would control immigration, and it would do so according to the nationalistic vision that it had. This worldview laid out in the act is still the foundational principle in immigration law today. Example, Attorney General in charge of the Department of Justice, Jeff Sessions, was quoted as saying this in a conversation with Steve Bannon from the Breitbart in 2015. Sessions' support for the Johnson-Reed Act is eerily in line with the ideas supporters of eugenics had in the early 20th century, which essentially blamed swaths of people for America's quote-unquote moral decay, particularly low-income people, those in prison, women, the disabled, and immigrants. This belief system remained in place for a long time and underpinned the government approach to immigration. After John F. Kennedy was assassinated in November 1964, Vice President Lyndon B. Johnson vowed to carry out his proposals for civil rights reform. A very notable act is the Civil Rights Act of 1964, which laid the groundwork for a number of other pieces of legislation, including the Voting Rights Act of 1965 and the Immigration and Nationality Act of 1965. The act ushered in far-reaching changes that continue to undergird the current immigration system, as well as set in motion demographic forces today. The law literally changed the face of America. It ended an immigration admission policy that was based on race and ethnicity and gave rise to large-scale immigration, both legal and illegal. At the time, lawmakers may not have realized the sweeping impact. President Johnson is quoted as saying during the signing ceremony that the bill we sign today is not a revolutionary bill. It does not have effect on the lives of millions. It will not reshape the structure of our daily lives or really add importantly to either our wealth or our power. Senator Ted Kennedy, the bill's floor manager, is quoted as saying, "It will not upset the ethnic mix of our society." So has the U.S. experienced unintended consequences? Because in only a matter of years, the U.S. demographic profile began to transform. The number of new lawful permanent residents rose from a little under 300,000 in 1965 to nearly 1 million each year since the mid-2000s. Additionally, the foreign-born population has risen from 9.6 million in 1965 to a record high of 45 million as of 2015, with the largest share of immigrant population today coming from Mexico. Let's think back to that agreement between Mexico and the U.S. Pretty interesting. So if lawmakers at the time intended to loosen the immigration laws while still maintaining the white European descent majority, they failed. According to Pew projections, by 2065, 46% of the U.S. population will be white, 24% will be Hispanic, and 14% will be Asian. Opinions differ on whether the 1965 Act helped or harmed the country. The law's proponents see it as a historic success and assert that the estimated 59 million immigrants who have come to the United States since its passage have made the country younger, infused it with diversity and talent, and generated prosperity and economic growth. Critics contend that high admission levels of diverse groups of immigrants have created more competition for low-skilled U.S. workers and shattered the country's cultural homogeneity. I imagine if one is on the latter side of the fence, then they could be experiencing fear of what this change may do to their daily life. But then again, there's just random Kens and Karens running around these streets. The truth is, many immigrants have surpassed median U.S. educational attainment levels, household incomes, and workforce participation rates. The Indian diaspora, for example, numbering 3.8 million, is significantly higher educated, more likely to be employed, and has a higher household income compared to the U.S. population as a whole. Those recorded from the Philippines, Bangladeshi, Pakistani, Egyptian, Kenyan, and Nigerian tell similar stories, while the diasporas of other countries such as Ghana, Morocco, Ethiopia, and Colombia are generally on par with the medians of their U.S.-born counterpart on most indicators. So while the 1965 law has empowered many diverse immigrants and their families to build new and prosperous lives here in the U.S., others are clearly hindered from realizing this same experience. Different laws and acts have been in place and repealed since then that impact how our immigration system works or doesn't work, such as the DACA, the Deferred Action of Childhood Arrivals. It asserts that certain people who came to the United States as children illegally but meet several guidelines like being in school or free of any felonies may request consideration of deferred action for a period of 2 years, basically an exercise of prosecutorial discretion to defer removal action deportation. They also are eligible to request work authorization, but this act does not provide lawful U.S. citizenship status. In July 2021, the U.S. District Court for the Southern District of Texas ruled DACA illegal. The Department of Homeland Security, or DHS, will continue to accept the filings of these requests. However, they are prohibited from granting approvals. Back to Title 42. So we are still discussing immigration issues. The Biden administration set the Title 42 policy to end in May 2022, but under court order after litigation by state attorneys generals, to block the termination, it remains in place. Remember Del Rio, Texas, when we saw the mass expulsion of Haitian people who arrived at the U.S. border seeking asylum protection following civil unrest that erupted from the assassination of the Haitian president, as well as a 7.2 magnitude earthquake that devastated that nation. Tens of thousands of Haitian men, women, and children were sent on flights back to the violence and instability in Haiti without being provided access to the U.S. asylum system, which was in fact a blatant violation of asylee protection obligation under U.S. and international law. Meanwhile, the U.S. continues to classify Haiti as a level 4 security risk, advising U.S. citizens not to travel to Haiti due to kidnapping, crime, and civil unrest. So, hey. Now, back to present day. Why are we going down this rabbit hole? Title 42, the Trump-era public health order that restricted migrants from crossing the southern border, had been set to expire on Wednesday until the Supreme Court issued a temporary halt on the expiration late on Monday, even though Biden wanted to end the policy. Republican attorneys generals from 19 states have argued that lifting the restrictions would likely cause a surge of illegal immigration at the southern border. There has already been an increase of people attempting to migrate to the U.S. in recent weeks. During an interview with NPR hours before the Supreme Court issued its stay, Vice President Kamala Harris is quoted as saying, "I think that there is so much that needs to happen to address this issue. And sadly, what we have seen in particular, I'm sad to say, from the Republicans in Congress is an unwillingness to engage in any meaningful reform that could actually fix a lot of what we are witnessing." So I'm not putting anything solely on either political party. I personally apply political impartiality. No one to me is ever 100% right or 100% wrong in politics. But quotes like this frustrate me, and I would imagine many other Americans as well, because bipartisanship is needed in everything our government does if we want to get anything accomplished. It feels like watching 3-year-olds fight over a toy. I would like to see cooperation from both parties to create real solutions to our immigration issues. The fact of the matter is, human beings are being affected, those that are born in the U.S. and those that weren't. So please drop a comment in the comment section with your thoughts. I'd love to hear your take on this. Now that I've traveled down this rabbit hole, it's time for me to exit. If you enjoy this content, please go ahead and click that like button and subscribe to see what rabbit hole I'll end up in next. Until next time, guys and gals, have a wonderful day.